Welcome to Epstein, Becker Green's Employment Law This Week podcast. I'm George Whipple. EEO-1 reporting requirements could soon be lifted. These reports include employee demographic data, such as race and gender. Employers with more than 100 employees have submitted annual EEO-1 reports since 1966. The Equal Employment Opportunity Commission is now proposing the complete elimination of these reports, along with the rescission of EEO-2, 3, 4, and 5 reports. This action follows the Trump administration's directive to eliminate DEI initiatives. However, to become law, this proposal must make it through many administrative steps, including a 60-day comment period before September 30th. Employers should thus proceed with plans to report 2025 EEO-1 data. Also in line with this directive, the EEOC is proposing to repeal protections for employers implementing affirmative action plans in the workplace. We'll keep watching both proposals for updates. The Fifth Circuit rules on remote work accommodations. After an employer denied a worker's request for full-time remote work, reasoning that one of his essential job functions was in-person work, the employee sued the company for disability discrimination, failure to accommodate, and retaliation. Upholding the lower court's ruling, the Fifth Circuit denied the employee's claims. The court found that in-person attendance is an essential function of most jobs, and that COVID-era accommodations do not determine what are considered essential job functions today. This ruling could prove informative as more employers implement return-to-office policies. Tennessee joins the nationwide trend of restricting non-competes. Tennessee employers will soon have new requirements for non-compete agreements. Beginning July 1st of this year, non-compete agreements will be unenforceable in the volunteer state for employees who earn less than $70,000 a year, inclusive of wages, salary, commissions, non-discretionary bonuses, and other forms of remuneration. In addition, restrictive covenants with Tennessee employees and independent contractors will be considered unreasonable if they cover a period of more than 2 years. The new law will also permit Tennessee courts to modify restrictive covenants to render them reasonable and enforceable. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker & Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.